Good morning, everybody, and welcome to this first webinar on the CUTLER Wait, let me mute everybody first. Okay, here we go. So welcome everybody to this first webinar on the CUTLER project, during which I will briefly touch upon all the legal issues that we've faced as a legal team in the context of this Smart City project. So what I'll discuss today are, everything is applicable in the context of CUTLER, but I believe that it might also be very useful for any kind of smart city environment. So of course, feel free to take some notes and come up with questions at the end of the presentation. I'll be happy to take them. A very brief introduction about myself now. My name is Pierre Dewitte, and I'm working for the KU Leuven Centre for IP and IT Law here in Belgium. And I've been dealing with, basically the legal issues in the context of the CUTLER project together with Alexandra Kucherawi, my colleague here. And I'm basically very active in everything that relates to data protection. A couple of comments and remarks. So as you know, the webinar is live streamed on Facebook. It will also be recorded, so we'll share the recording on the CUTLER YouTube channel as well on the Facebook page. The presentation will also be shared on the CUTLER website. I muted everybody, so of course I won't hear you. Feel free to unmute yourself in case you have a question at the end. You can switch your camera on if you have a question as well, if you want. And as I said, the question will be taken at the end. So write in the chat or raise your virtual hand as WebEx allows, and I'll take the question at the very end of the presentation. So starting with basically the CUTLER project in a nutshell, as well as its implication and the objective of the project, because it's the first webinar of a really long series of 8 webinars. So I thought it would be quite useful for the audience to at least recap some of the main points of the CUTLER project. And it's also crucial to check those, well, because most of the legal implication come from, well, the environment of the CUTLER project and the ideas behind the project. So as you can see on this visual, the CUTLER project is mainly divided into 3 main phases. So the first one, as you can see on the right-hand side of the screen, is a collection of a bunch of data. And I guess that's also the fact, that's also a starting point for any kind of smart city project. You'll need to gather a bunch of data. And in the context of CUTLER, we decided to gather some open data sets, but also gathering information from, statistical offices, for instance. There were a bunch of sensors that were installed in some of the city pilots, so we decided to gather some data from there as well as have some data from, the user directly, for instance, and I'll briefly touch upon that later. So with that data, we decided to create a big data analytics hybrid cloud infrastructure, so basically in the form of a dashboard that could basically process that data and then be used to inform policymakers in order to reach better decision making. So as you can see on the left-hand side of the screen, this time the approach that was adopted when it comes to informing policymakers was the IMR method, which goes for inform. So basically you need to inform policymakers about all the data gathered in the first stage. You also need to advise them, so basically recommend the actions to be taken, to monitor the implementation of the certain policies that were basically adopted on the basis of the data that was gathered, evaluate them in case something was wrong, and also revise them, of course, if change was needed. So those are really the three main pillars of the CUTLER project: gathering data, processing the data, and using the processed data to then recommend actions to be taken by policymakers. So in the context of the CUTLER project, that was done together with 5 different cities. But each city basically had a different ID, a different goal in mind, and that's what we called the pilot case. So the first city was basically Thessaloniki, and the goal there with the CUTLER project was the development of the Thermaikos Bay area. The second city is Antalya, and in Antalya they wanted to develop and also increase the visits in the recreation and park area of Duttenbroek. In Cork County, it was basically the idea was to develop and to improve the visitor, basically improving the whole system for the visits of the Camping Fort Meer. In the city of Antwerp, in Belgium, here it was the goal was to basically develop a storm water plan. And for the recently joined city of Vicenza in Italy, it was the idea was to have a flood risk management tool. So those really are the 5 cities that we're dealing with in CUTLER, and they each had a different idea in mind for what the dashboard could basically be used for. So that's CUTLER in a nutshell. Of course, when you are dealing with smart cities, as I said before, you need a whole bunch of data to make it work. Otherwise, you're not going to be able to implement any kind, at least in our case, of efficient policy making. So you need to gather vast amount of data sets. And in the in the context of the CUTLER project, well, basically three types of data were gathered and processed. The first one was economic data, so indicators such as the employment rate, touristic affluence, some macroeconomic indicators, etc. That was really the first type of data that was gathered and collected in the context of CUTLER. Next to economic data, we also gathered environmental indicators, for instance, air pollution, the temperature, the water quality, the water temperature. So again, all those environmental indicators that were quite useful to either direct or hint at efficient policies, or basically to evaluate some of the existing ones. And the third type of data that was collected, because that was quite important as well, is societal data. So for instance, we had some open participatory platforms through which citizens could themselves give their opinion on a given policy. So if they had anything to say, they could basically share it with policymakers directly. And we also took into account direct suggestion by citizens. So that's something that was more related to the societal aspect of things. So of course, following that, the first essential requirement in any, well, in CUTLER obviously, but in any kind of smart city endeavor is really to have a good overview, a good, comprehensive and up-to-date, that's very important, overview of all the data that will basically be gathered and processed. So that's really the essential first step. So gathering data is one thing, but of course, gathering data is also something that is heavily regulated in law. And of course, since this presentation today is about the legal side of things, we'll discuss a bit the potentially applicable regulatory frameworks. So obviously, when you're thinking gathering data, the usual suspect and the thing you will probably think about first is privacy and data protection. And indeed, that is a really important aspect of the regulatory frameworks that we need to take into account. You probably heard already about the General Data Protection Regulation, which is also now announced as GDPR, but that's not it. There are also other regulatory frameworks, such as the e-privacy directive, for instance. We've heard about that for a while, because at some point there was a discussion to go for a regulation, but it hasn't, yeah, anyway, that's something that hasn't been done yet. So we are stuck with the e-privacy directive, but it's still there. There has been a new regulation on the free flow of non-personal data as well. So that's something that we needed to take into account too. Privacy and data protection is certainly a thing, but again, that's definitely not the only type of regulatory framework that can play a role here. You also have intellectual property rights. So some of the data sets that city pilots might want to gather and to process might basically be protected by intellectual property rights. So for instance, it can be protected by copyright law or by database law, or it can even be considered as a trade secret, for instance. So that's something we needed to take into account as well. Thirdly, there exists basically some open access regime. So if you're acting, for instance, as what we call in law a public sector body or a public authority, which is likely to be the case in a smart city environment, then you are also facing some other regulatory requirements in the form of, for instance, the PSI and the Open Data Directive, but I'll come to that a bit later. The Access Directive or the Inspire Directive, for instance, when it comes to spatial data, but I'll come to that later. And lastly, but not the least, to be honest, when you are collecting data directly from another type of platforms, and I'm thinking, for instance, APIs from Facebook or from Twitter or even from TripAdvisor, for instance, you are also basically tied to them with a contract, right? So if you're using an API to gather data in the context of a smart city initiative, you are very likely to be bound by contract with the platforms as well. So that's very important that you keep those contractual terms in mind, because they will impose you some limitations, for instance. But again, that's something I will briefly touch upon later. So if the first essential requirement of a smart city initiative is to have a really up-to-date and comprehensive overview of all the data that you're collecting, the second essential requirement is essentially to, well, be careful for all the legal requirements that you might need to comply with. So that's really the second essential requirement that you need to be aware of. And in that context, we decided to develop what we call the CUTLER methodology to deal with all those legal requirements. And the idea here was that we would be able to pair each data source processed in the context of CUTLER with one or more element of a taxonomy that we have developed. Again, I'll come to that later. That would basically allow any kind of person working in the city pilots to directly match a given data set with the legal requirements that they have to comply with. So that's the idea behind the CUTLER methodology. I present it here without an example because, of course, for this to work, you need essentially four prerequisites. The first one is that you need to know the data sets that you'll be collecting and processing. That's really essential. The second thing that you need is to develop, and that's at least the way we decided to deal with that, a taxonomy, so a legal taxonomy in our case, that will basically allow you to qualify the data sets that you've identified in step one. The third essential step is then to qualify, of course. So now you have an overview of the data sets, you have your taxonomy. Each piece of data needs to be qualified according to one or more element of the taxonomy. That's the third step. And lastly, you need to basically, it's a bit complicated to go through every regulatory framework individually and to check what you can do, what you cannot do. So in the context of the CUTLER project, we decided to address that by just streamlining all the rules into what we call legal requirements. So those four elements are essential for the CUTLER methodology to work, and I'll revisit each of those now in the presentation. At the end of the presentation of those four elements, I'll just go through the CUTLER methodology again, illustrate it with an example, so hopefully that will be clearer for you. The first step, as I said, is to identify all the relevant data sets that will be collected and processed in the context of the Smart City project. In the context of CUTLER, we decided to create a catalog of datasets used by city pilots on a dedicated CUTLER wiki, and that was continuously updated by city pilots. So if you're interested to read about that, the relevant deliverables are deliverables 3.3 for the initial version and 3.5 for the updated one. The links are embedded in the presentation, so if you want to have a look at them, you will just basically be able to click on the link and you'll be having access to the document immediately. This is basically a screenshot of what the catalog of dataset looks like for one of the city pilots. So here I'm taking the example of Antwerp, and that's the screenshot basically of the wiki that we've been using over the years in the context of the CUTLER project. So as you can see, you have a bunch of links, and everybody having access to the CUTLER wiki could basically click on one of those links, and then you would have access basically to more information about each piece of data collected in the context here of the Antwerp city pilots. So as you can see, we've divided them, as I discussed before, between environmental data sets, social data sets, and economic indicators as well. And for us, the legal team basically was really crucial to have this overview because we could then click on each of those data sets and see what it would look like, right? So I'm thinking mainly privacy and data protection here to check whether that might qualify as personal data. It was essential for us to see an example of a data set. So that's essentially what the catalog of data set was for, a repository basically for us to always check. And of course, that was continuously updated by city pilots as the project went on. Okay, so now we know exactly what are the data sets collected and processed in the context of Smart City and in context of CUTLER in this case. So we needed to develop that legal taxonomy of data sets. The idea behind that was that we would need to identify all the potentially applicable regulatory frameworks. This is a lot, I reckon, but the thing is, when you're delving into a Smart City project, you will quickly realize that personal data, of course, is a thing. The GDPR is definitely there. But as I said before, you have a bunch of other regulatory frameworks applicable. So the taxonomy that we developed was basically based on an analysis of the scope of application of each of those regulatory framework. And then we had those different elements of the taxonomy. So every potential qualification was basically excerpted from the scope of application of those regulatory frameworks. The first one, obviously, is personal data, GDPR, but also electronic communication data from the e-privacy directive, non-personal data, since the new regulation on the free flow of non-personal data, copyrighted data, so basically data protected by copyright, data protected by databases, because that's also something, that's another type of intellectual property right that exists, data protected by trade secrets. So we have a new trade secret directive, not that it's really crucial in the context of Smart City, but it might sometimes have an implication. So we decided to include it in the scope of our analysis. Public sector information. So that's something that has changed very recently because we now have a new directive on the matter. Environmental information, of course, as you've seen, and as I said at the beginning of this presentation, we have a lot of environmental indicators that we gather in the context of CUTLER. Spatial data, same applies there as well. There is a specific regulatory framework dealing with that. So voilà, those are the elements of the taxonomy that we decided to develop in the context of the CUTLER project. The goal of today's presentation is not to really delve into all the potential rules that can basically stem from those regulatory frameworks, because then an hour would be way too short, to be honest. But if you're interested to read about that, the relevant deliverables are deliverable 1.1. Again, you have the link here for the initial version, and deliverable 1.4 for the updated version. Still, some example of the taxonomy of basically data sets that we decided to develop, starting with personal data. So as you know, probably personal data, it's regulated by Regulation 2016-679, which is also known as the GDPR. The GDPR defines personal data as any information relating to an identified or identifiable natural person. So those are the four kind of building blocks of the definition. And if you're falling within the scope of application of regulation, well, some of the most important consequences will be that you will have to abide by some of the general principles that are governing the processing of personal data, essentially. So I'm thinking limitation, lawfulness, data minimization. Again, it would be way too much to develop everything here, but the idea is that you would need to comply with those general principles. You would need also to comply with data subject rights. So in case somebody asks for instance, an erasure or delay or a rectification, for instance, that's something that you would need to accommodate. Data protection by design is also one of the new obligations in the text. If you are engaging some processors, for instance, to work for you, you need to draft contracts. You have the obligation to keep a record of processing activity, to basically enforce corporate security, to notify in case of personal data breaches and everything. So again, that's really a brief overview, and it would be too much to delve into everything. But if the data sets that you're collecting and processing basically falls within the category of personal data, there's a lot to comply with. What kind of data sets in our case could potentially qualify as personal data? Well, I've mentioned those participatory platforms to which citizens could basically share their opinion on a given policy. Well, in that case, there is a high chance actually that some personal data will be processed as well. I'm thinking as well traffic fines, for instance, in the case of one of the city pilots, some traffic fines information were gathered as well. Again, a license plate, for instance, there is a very, very high chance that you'll fall within the scope of application of the regulation, and therefore you will have to comply with some of those principles. So that's something that is quite important to keep in mind, because you will face quite a heavy regulatory burden in case you're processing personal data. Another example, as I said, is copyrighted data. So the InfoSoc directive that was recently revised by the, well, we call it Copyright in the Digital Single Market Directive, that has basically modified a bit the text. But anyway, so it might happen that you will process what we call an embodiment of a work that is original. So if you're processing something, a piece of information that basically reflects the author personality, where the author has been basically able to express creativity, for instance, well, that's the condition for copyright to apply. You don't need to register something. It's automatic as long as you, for instance, write a piece of text that reflects your own creativity, you will be protected by copyright. In that case, well, basically you cannot reproduce or communicate to the public or distribute that content, right? You need the authorization of the right holder. So in that case, you need to ask the person who basically is the right holder, so the person who created that piece of information, whether you can use it. I'm thinking, for instance, of a journal article in the context of CUTLER. So if you're, for instance, scraping like text that is protected under copyright, you might basically fall within scope of application of the InfoSoc directive. Same goes for tables and charts which have been created by someone else and which might demonstrate the author's personality. So you have a bunch of exemptions, of course, and I'll come to that in another example a bit later. But the idea here is if you're basically collecting and processing data that might fall within the scope of application of the InfoSoc directive, you might want to clear that out first and check whether you might need the authorization of the person who created the data set at stake. Okay, let's go to open access regime. I said that there's something called publicly held documents. So here it's a bit of so we have two regulatory frameworks that are relevant here. The first one, most cities might already know that it's called the PSI directive, so the Public Sector Information Directive. It will be applicable until the 17th of July 2021 and will be replaced by the new Open Data Directive as of the 17th of July 2021. So now we have two relevant regulatory frameworks, but the scope of application has not changed that much. So it applies to what? It applies to documents. So any content, it's really a broad definition that is processed by what we call a public sector body, so a PSB. Again, the definition is extremely long. If you're interested, you can check page 65 of the deliverable 1.1 to have an overview. But basically, the idea is that a public sector body, an administration, for instance, in the context of a smart city project, is highly likely to qualify as a public sector body. So if you have a document that is basically processed by a PSB in the context of its public task, which again might be the case in the context of a smart city project, you will likely fall within the scope of application of the PSI/Open Data Directive. So the impact is that if you are such a public sector body, you might be faced with requests from other people to basically get access and be able to reuse the data that you've created. So you won't be obliged to basically give access to the data sets that you've created, but you will be obliged to, well, basically accommodate the request in accordance with a bunch of principles. So I'm thinking, for instance, there are some principles on charging. For instance, there is a maximum amount that you can charge if charging is even allowed. There is requirements for machine readability. For instance, if you're providing data in a common format, you might be required to go the extra mile and just provide it in a machine readable format. Same goes for licensing. I mean, you will basically be required to consider requests for use in accordance with a bunch of principles that are listed in Article 4 to 11 of the PSI directive. So too much to go into details here, but that's the idea. If you are not a public sector body, then you have the basically possibility to request access to the publicly held documents. So that's also something that you might want to use as an administration, although there is a limitation for PSB requesting access to other PSB. But yeah, the idea is there. The type of data sets that might qualify as a publicly held document, really, it's literally anything that is basically produced, processed, collected by a public sector body in the context of its public task. So again, it's extremely broad. So it's very important that you are aware of the obligation that you might face. Last example, I believe, is environmental information. So the instrument here is Directive 2003/4, which is also known as the Access Directive. It applies to environmental information, so any information that relates to the environment. Again, I didn't put the list here. Check it out in the deliverable 1.1 if you're interested. But it's extremely broad. So everything that basically touches upon environmental information is basically considered environmental information. And if you're processing it as a public authority, so here the scope is a bit different. It's not public sector body, it's public authority, but the idea again is the same. You will likely fall within the scope of application of the Access Directive. What you will have to do then, again, is to consider requests for making that data available according to a bunch of principles. And if you are not a public authority, you can also maybe requesting information from other public authority. I'm thinking, for instance, the measurements of air pollution or water pollution in context of the CUTLER project. Those are examples of data sets that do qualify as environmental information. And as such, a city pilot, like one of the cities we've been dealing with in the context of CUTLER, it didn't happen, but could have been asked to basically share that data with somebody else. Okay, so now we know what are the type of data that is being collected. We know exactly the elements of the legal taxonomy. So it was about time we needed to basically qualify those data sets according to the elements of the taxonomy that we had developed. That's the idea here, really to link those data sets with one or more elements. Could be one, could be 2, 3, 4, depending on the data set, to be honest. If you want to have a look at the full qualification of datasets, I encourage you to go and look at deliverable 1.2 and 1.5. The first one is, again, the initial version that was drafted halfway through the project, and the other one is the one that was drafted nearly at the end of the project, because obviously we had some changes in datasets, we had some changes in the regulatory frameworks themselves. So we needed to basically adapt ourselves. The way we decided to do that qualification exercise is just basically through a table. So here again, you'll see an example of the data sources that are collected and processed in the context of the Antwerp city pilot case. So on the left hand side of the screen, you see all the data sets identified by their unique identifier. So you could look basically for that name in the catalog of data sets, and you would immediately find which data set it was relating to. And then at the top of the table there, you have all the elements of the legal taxonomy that we have developed. And then, to be honest, the rest was just having a look at the data sets, having a look at the scope of application of each regulatory framework, and then qualify each of those data sets according to the elements of the taxonomy. It's reflected by a cross there where it is relevant. So, for instance, you see that some data sets qualify as non-personal data, most of them actually. Most of them also qualify as publicly held documents. As I said, that's also a consequence of the fact that when you are an administration, for instance, there is a very high chance that you will qualify as a public sector body or as a public authority in the context of environmental data. So voila, that exercise was performed individually for each dataset, which was quite time consuming, but in our opinion, that was a necessary step to basically go from one piece of data that you're collecting to, okay, that's the rules that I need to abide by, for instance. So that was kind of a long exercise, but we had the team here at KU Leuven dealing with that with the help of city pilots to better understand each datasets. The fourth step was, as I said, to elicit all the legal requirements. So the idea behind that was, I think it's already apparent from the presentation today that there are a lot of rules to be complied with. That's for sure. And we were dealing with 5 city pilots who did not always have a clear overview of all those rules. So it was kind of new in some cases. So we really needed to translate all those rules that were sometimes very difficult and very complicated into concrete actionable rules that they could take. Basically, they needed to implement their own data policies, for instance. They needed to know exactly what to do rather than just going through the regulatory frameworks each well individually, let's say it like that. So we needed those requirements to be clear. It should, well, basically the idea that it should be easy for city pilots to basically understand what they have to do, complete. So it's not because we simplified some of those rules that we decided to bypass others. So we really wanted to be comprehensive here. And we also needed them to be conflict-free in the sense that, yeah, it's basically bad in this situation to have a conflict between one requirement and the others, because then you have a conflict of policy. So those were the quality requirements that we wanted when we drafted the legal requirements. I'll show some example of those legal requirements next, but in terms of formatting, we decided to organize them in categories and to associate them with different city pilots, because of course not every requirement was relevant in the context of either all the city pilots or all the data sets. So as you will see, the structure basically reflects the fact that for some data you needed to comply with those principles, and for other data, or for other city pilots, you needed to comply with other data sets. Very important point here, as I already hinted at before, the qualification exercise was, and to a certain extent, is still a continuous process in the sense that the catalog of datasets was just basically, it was impossible to define from the very beginning all the data that would be processed and collected in a context of CUTLER. So the catalog of dataset has evolved over time. So if you look at the first version of the data catalog, it looks nowhere as complete as the data catalog that we have now, because basically city pilots decided to change their minds, which is perfectly fine, on some of the data that they would rely on. Some of the data sets disappeared, new ones appeared, so basically the catalog was really changed over time. Also, the qualification was not rigid, and that's also an issue that I've been mentioning before. We had some new regulatory frameworks, of course. I'm thinking, for instance, the new copyright framework or the new open data directive that has replaced it, that will in 2021 replace the PSI directive. it has changed basically over time. So the qualification was not definitive either. So we really need to keep things up to date. And that's the reason why I say that qualification is a continuous process, because we really need to go through the catalog over again to make sure that everything was updated. If you're interested to have a look at that, again, deliverable 1.2 and deliverable 1.5 for the updated version are the go-to text if you want to delve a bit into, well, basically all the legal requirements that we drafted, because I won't present everything. I think it's a 80-page long deliverable, impossible to present now, but I'll present some examples. So as I said, yeah, impossible to go through everything today, but the structure looks like that. So we have every time a table with a unique ID that would allow us to easily cross-reference each requirement in the text, for instance. We had the short name for each requirement. And then very importantly, we had a code, and the code was basically linking one requirement with the type of data and with the city pilot. Because of course, as I said before, not all requirements will be relevant for every city pilots or for every type of data sets. Then we had degree of importance ranging from low to medium or high. A quick description that was basically well describing what you need to do with the data in case you would fall within that requirement. And then a piece of extra information in case you wanted to go further and get extra information, for instance. So some examples of those legal requirements. Here I'm looking at requirement priv, so that's privacy and data protection. Pro, because it was the requirements applicable in the context of the processing of data and not the collection. 3.5, so that's basically the ID behind the code. The short name, although it's not that short, was exception to prohibitions for sensitive data, applied in the context of social media, so it's already quite long for a short name, but it was kind of necessary. The code, as you can see here, is PyAll, and PyAll basically refers to the fact that it's applicable to all city pilots, 5 of them. And SOC basically says that it's applicable to societal data, right? So not the environmental data, not the economic data. Priority here is medium. And the description of this legal requirement is the fact that the GDPR basically forbids the processing of what we call special categories of personal data. So data that basically reflects your political orientation, sexual orientation, membership, for instance, to a trade union and stuff like that, or health data. So those kind of sensitive data, as we say as well, you cannot basically process them. There is a clear prohibition for the processing of personal data in the GDPR, but you have a bunch of exemptions. Among those exemptions, you have the fact that the data that you're gathering, even though it's sensitive, has been made public by the data subject. So if you are gathering data, so personal data in that case, from social media, because that was the case in these pilots, well, then you need to make sure that the data has been made publicly available before. That is the exemption that we decided to go for in the context of the CUTLER project. And the requirement here reflects that. So in the comments, there is a more extensive definition, so referring to the articles in the regulation. So that's the idea here. That's one requirement, a very precise requirement when it comes to privacy and data protection. Another requirement, this time again, priv refers to the fact that it's still privacy and data protection. Non-pers refers to the fact that here we are dealing with non-personal data, and that's requirement 1.2. Short name is availability for competent authorities, which applies to all city pilots for all type of data. Priority was here again medium, and the idea behind that requirement is that competent authorities in the context of, for instance, criminal investigation couldn't be refused to get access to the data on the basis that the data was processed in another member state. So it didn't happen, and to be honest, it's quite unlikely to happen. But if you are gathering data as a public authority, for instance, you might be requested by a competent authority, so an administration in your country, to actually grant access to the data. If that happens, well, all the requirements said here, because it's also strictly excerpted from the new regulation on the free flow of non-personal data, is that should that happen, you cannot refuse to grant access to the pieces of data they're requesting just because it's not processed in your own country, right? So you cannot say, for instance, okay, I'm in Ireland, an Irish competent authority require access to the data, but the data is basically stored in Belgium. You cannot deny access to the competent authority of your country, so the Irish one, because the data is basically processed and stored in Belgium, for instance. Very unlikely, to be honest, but as I said before, we really wanted to be comprehensive here, so we decided to include it. That's an example of very, very specific requirements. Another one here, IPR, which refers to intellectual property rights, CPR for copyrights, and 2.3, because that's the numbering of the requirements. A mandatory exemption for what we call text and data mining, which applies to all city pilots for environmental datasets and economic datasets. Priority medium here, and the idea behind that requirement is that, as I said before, if you are processing copyrighted data, you might need, you cannot reproduce without basically the authorization of the right holder, unless you are engaging into text and data mining. And text and data mining is basically one of the new exemption that was introduced by the Copyright in the Digital Markets Directive. So if you're just mining stuff from like for instance from a text, right, that is protected by copyright, well, you might benefit from this exemption, and then the authorization of the right holder might not be necessary. So again, that's something that might be extremely useful if you're, for instance, mining. I'm thinking about like a journal, for instance, a newspaper. You might check all the news and mine the information for the name of your city, for instance, to check what people are saying in the news about that. Well, this is an example of processing of copyrighted data that might fall within the new exemption of text and data mining. So quite important to keep in mind. And the last example here is open access. So open PhD refers to publicly held documents. Short name being ODD because we have the PSI, we have the Open Data Directive. So here I wanted to emphasize that it's just related to the Open Data Directive. And that's the access by third parties. So again, this applies to every city pilot and for all the data sets connected. So description here is basically if you're producing research data as an institution, you need to consider the provision of access to the data to third parties that are willing to reuse them for any commercial or non-commercial purpose. So again, that's something that is quite likely to happen, and you need to bear in mind that you might just be requested to give access to that kind of data sets to third parties. And now a brief recap of the CUTLER methodology with an example. So the first step was really, as I said, to have a clear picture of all the data that is basically collected and processed. Let's say that in the city pilots, you're collecting citizens' opinion on a given policy. You'll collect water temperature data. You'll collect touristic affluence for a given period. Now you know exactly what you're collecting and processing. Let's focus now on water temperature data. Water temperature data, according to the taxonomy that we have developed, can be qualified as a publicly held document. Environmental data, spatial data, it can be potentially protected by a database. So that's the whole array of the elements of the taxonomy that are potentially applicable. Let's focus on publicly held document now. If you are a publicly held document, one of the requirements is that you will have to consider the request for reuse according to Article 4 to 11 of the PSI directive. So that's an example of how you go from, okay, that is the data that I'm collecting and processing, and that is what I need to comply with. And the last point for today's presentation, because I think this is also quite relevant in light of the whole fuss about the GDPR, is how do you basically deal with the allocation of responsibilities in the context of a smart city project. So when you have a processing of personal data, so when basically you are falling within the scope of application of the regulation, and basically when you tick the box of, okay, personal data is one of the data sets that I'm collecting, you then need to identify a controller. So the controller is basically the natural or the legal person that will determine the purposes and the means of the processing. Why is it that crucial? It's very important because the controller will eventually be the entity that bears responsibility for compliance, and if anything goes wrong, the controller will also basically be held liable. So it's very important to know which entity in the smart city project will bear controllership. Now, for a controller, it is very possible that you will delegate part of your processing activities to another entity acting on your behalf. That's what we call the processor. So the processor, well, you can basically do that, but then if you're going down that road, you need to draft a controller processor agreement that is extensively regulated by Article 28 of the regulation. So there's a bunch of information that needs to be included in the contract. And that's something that we also had to take care of in the context of CUTLER. There are many different ways to allocate responsibility in a smart city project. The main idea is that it should reflect reality, so you should not artificially divide the responsibilities among entities that actually do not control anything. But still, there is some leeway in the way you are allocating responsibilities. In CUTLER, we decided to go for the approach each city pilot was considered as a controller, and then each corresponding technical partner, so for instance for the collection of the data, or for instance for storage, was considered as a processor. So we needed to basically draft contracts between each city pilots and all of their corresponding technical partners. So that's the way we decided to deal with the allocation of responsibilities in the context of this project. But of course, you have other options if you want to avoid extensive responsibilities for each city pilot, for instance. And that closes the legal presentation. So if you have any question, of course, feel free to write them in the chat. I don't see any now. Or feel free to unmute yourself as well. And if not, that's fine as well. Okay, I don't think there are any questions, Fidelity.
Let's give it a minute.
Sorry, you said? Still no question? Again, feel free. You either can raise your virtual hands in the chat box, or you can just unmute yourself and raise a question. Okay, I guess that closes it then, if no question. Well, thank you very much, everybody, for attending. In case you still have some issues that you want to discuss, I remain available via email. You had my email address before. The presentation will also be shared in the PDF formats, I think via email, but Fidelity, correct me if I'm wrong. So you will have access to the slides, and in the slides, as I said, you also have the hyperlinks to the relevant deliverables in case you want to have a look at the text.